But this revisional application was prepared, challenging an order passed in a eviction appeal, my lord. But wherein in eviction suit, I was the tenant, I lost. In the appeal, my lord, I filed the appeal. The stay was granted on condition that I have to pay the occupational charge 5,000. Initially, it was 150 against a residential room in the ground floor, measuring about 125 square foot. And I moved this application before your lordship, and your lordship was pleased to uh, grant me the liberty to pay the occupational charge, enhancing from 150 to 2,500. I paid 2,500 because the appellate court granted it was 5,000. Yes. And I challenged the revisional application because, my lord, the 5,000 was granted mechanically without giving any reason, without going through anything.
Yes, very well. It was turned to 2,500.
It was reduced to 2,500.
Yes.
I deposited 2,500 regularly and served the notice upon the parties. They never appear. Now I praying before lordship to dispose of the application without, as your lordship fits in any passing any
bench.
Because, my lord, because they are not coming, my lord, and I have to face the consequences.
So I am passing a specific order.
My lord, because I have deposited
order. If they are not appearing,
well, this is the rent
receipt disposed of in the regular bench.
Well,
it would be better. Otherwise, it is not.
As your lordship, I have served them, my lord. These are the rent receipts, my lord, and these are the affidavit of service, my lord.
Give me the affidavit of service,
my lord. Because after your lordship passes the order, I serve the copy upon them, my lord. Your lordship was pleased to hear the matter on 12/10/2022. Therefore, I served the order upon them. Subsequently, thereto also it was extended. I served the order upon them, and along with the petition, but they never turned up.
And they are regularly receiving the 2,500.
My lord, I have deposited. I have the last rent receipt. I have handed over to your lordship. Your lordship knows it very well because the last month it will be kept with the record. Otherwise, I can be able to deposit the next month's deposit. That's why I have handed over the deposit of month of July. Well, kindly come to order dated 12/10/2022.
Yes.
May I read it, ma'am?
Since then, they are not appearing.
No, my lord.
Very well. It can be disposed of today. Please take down. The instant CO has been prepared for by the petitioner against the occupational charges ordered by the appellate court to the tune of rupees 5,000 per month. It is the submission of the learned advocate for the petitioner that the amount of occupational charges is exorbitant. So he moved the instant CO before this court. After hearing the learned advocate for the petitioner, an order was passed by this court on 12th of October 2022, directing the present petitioner to deposit the occupational charge of rupees 2,500 per month instead of rupees 5,000. The petitioner was also directed to serve upon the opposite party in respect of the order dated 12th of October 2022. Stop. Next, it appears from the affidavit of service that the petitioner has served upon the opposite party, and it further appears from the challan that the petitioner is regularly depositing the occupational charge of rupees 2,500 with the court, with the learned court bill. The entire revisional application is pending since 1 year, but on no occasion the respondents appear. How many respondents are there?
My lord,
Respondents appear.
9. 9. You kindly come to page 2 of my revision.
All item delivered.
All item delivered, my lord.
Learned advocate for the petitioner submits that the respondent is not at all interested to proceed with this matter or proceed with this matter, or they have no objection against the interim order passed by this court. Accordingly, the instant matter may be disposed of, confirming the order passed by this court in the interim order. Stop. Had the learned advocate peruse the interim order passed by this court on
12/10/2022.
12th of October 2022. Considering the entire circumstances, the instant civil revision is disposed of with a direction that the occupational charges as ordered by the learned appellate court to the tune of rupees 5,000 per month is hereby reduced to rupees 2,500 per month.
Yes, my lord.
CO along with the CAN applications are disposed of.
No can is there, my lord. Only
CAN is there.
no can is there.
CAN is there. The affidavit in opposition along with the challans are taken on record.
Affidavit of service and challenge.
Yes.
My lord, of one indulgence, my lord, instead of your lordship has stated respondents in the revisional applications, they have been described as opposite parties.
Opposite parties.
1, 2, and 3 are same, my lord.
Same order.
My lord, same order. Passed by your lordship on the same.
All 5,000.
All 150 to 5,000.
Same date of order.
Same date of order. Only, my lord, the eviction suit, ejectment suit, and the appeal number is different.
Okay, that would be otherwise. So all are 5,000.
All are 5,000. 150 to 5,000.
Very well. 1, 2, 3, same order. Next.
Great.
What was the last date? Okay, आगे 26. Pages. Page 2 and page 8.
Item 4.
Please, Your Lordship. Malad, this CO was taken up on 26th August and I was directed to serve notice on the opposite parties. I've served notice, Malad, they have received, I filed the affidavit of service. They have received on 28th by email and yesterday by hard copy. So 28th they have received. Malad, the short facts of this matter is such. Malad, I am the page 2, Malad, of the affidavit of service would show service by email, Malad. The order, your lordship, will maybe there in your lordship's file, Malad. Sorry, page 3. I'm sorry, Malad. Page 3 of the affidavit of service. 28th August at 4 p.m., Malad, it was sent. The order and the, Malad, CO petition was sent, Malad. Directions for notice was given on 26th August, Malad. The
Yes, what is the fact?
Malad, may I tell your lordship the fact, Malad? I am the owner of, Malad, the petitioners are the owners of Dag number 1 in mother premises 1 VIP road. They are the owners of Dag number 1. That has many other Dags. Now, Malad, the petitioners entered into a joint venture agreement with the other co-owners of the other Dags. And Malad, it was agreed that all these Dags will come together, Malad, and the land, the total mother premises land will be used for construction of a building. So my Dag will also be utilized for construction of a building by utilizing the FAR. So for this purpose, there's a joint venture agreement, and it is agreed that I will be allotted for my 15 cutters of land. I will be allotted the ground floor and the top floor of this new building, which is going to come up. Now, my lord, my urgency in this application is this, that I came to know in the month of October that these other co-owners had mortgaged the building, as a result of which, and they have suffered a decree against them in the debt recovery tribunal. As a result of that, my lord, the entire building is being put up for sale. So building in which I have 2 floors. So I moved, my lord, the learned court below. The learned court below, if your lordship sees the order against which I've come up with, was of the view that I have, and rightly so, my lord, but it could have molded the relief. What I had, by mistake in the prayer portion, I'm sorry, in the schedule B property, I had written the entire building, which I could not have. I could not have sought an injunction on the entire sale of the entire building because my right is restricted only to ground floor and second floor. So the learned court below, my lord, was pleased to decline my prayer for injunction, saying that you have sought injunction in respect of the entire building. You don't have a right in respect of the entire building, so your prayer for injunction is refused. There, my lord, I humbly submit that is not the correct position in law. My right, I've said in the plaint, is limited to 2. In the plaint, I've specifically said 2 floors in the Schedule B property. But the injunction application, I said injunction over Schedule B property. That is the defect, my lord, technical defect in the injunction, because of which my injunction was declined. And the settled law is, my lord, if a larger relief is sought, the court can always grant a smaller relief. Kindly see, my lord, once. Kindly see, my lord, I'll show your lordship the map to my conveyance deed, which will make matters very clear. Your lordship kindly sees.
Page number.
Please, my lord, kindly have first. My conveyance deed, my lord, starts at page 44. I'll not trouble your lordship with the full deed. Kindly come to 84 once, please, my lord. Conveyance is at 44 and 84 shows, my lord, my land. Your lordship sees the rectangular piece in the middle of the page, RS Dag number 1. And your lordship sees on the road side is RS Dag number 64, 63. The other Dags are there. They are all they are the road facing land. My land is behind. So, my lord, I enter into this agreement, which your lordship will find at page 98 with the owners of the other Dags.
What is your Dag number 1?
My Dag is Dag number 1, my lord, which is in the center, and it is surrounded by the other Dags. I am not concerned with the Dags behind, my lord, Narayan Das and Nidhan Kendro, Little Hut. These we are not concerned with. The Dags in front, my lord, your lordship sees 64. I enter into agreements with the owners of 64, 63, which your lordship will find at page 98, please, my lord. The petitioners are, my lord, the party of the first part, and I enter into these agreements. Now, my lord, kindly see page 99, please, my lord. 99, after whereas the different companies, being the second party, that is the other owners, my lord, had purchased by and under 6 several deeds of conveyance properties described in Schedule B to G hereunder. The second party is desirous of constructing a multi-storied building by amalgamating the lands described in Schedules B to G.
You are the first party.
I am the first party, Schedule A land. Schedule A land. Now, the floor area which is being permitted is insufficient. Now, kindly see 4. The second party has approached the first party, who is the owner of land behind the Schedule B to G land, and is desirous of using the FAR of the Schedule A land with the Schedule B to G land, so that a higher FAR can be obtained in respect of the multi-storied building proposed to be constructed on the Schedule B to G land. Then your lordship kindly sees the next. Kindly see serial 3. Whereas acting on representations of the second party, the first party has agreed to permit the second party to use the FAR arising out of the Schedule A land with the Schedule B to G land, so that FAR in respect of A to G land can be utilized for the construction of the multi-storied building on the following undertakings. Now, kindly see serial 3 on that page. The second party shall allot in favor of the first party constructed area in the proposed multi-storied building aggregating to 36,000 square feet, and would exclusively allot the ground and the top floor of the proposed B plus G plus 6-story building. And the second party then undertakes to construct, your lordship will see, construct a multi-storied building comprising of basement, ground and 6 upper floors according to the plans. And out of that, my lord, I get the first and sixth. Now, my lord, now first and sixth floor of this building, your lordship will see, now the building has come up. It is at page 112. The photograph of the building is.
You have been allotted the ground floor and the top floor.
And the top floor. My lord, your lordship, yes, your lordship, absolutely kindly see 104 once the schedules are given. The schedules of this agreement are given at 104. Schedule A is my land, and your lordship will see about 4 lines from the top, 15 katas, 13 chitaks, or so many square feet, more or less, situated and comprised of Dag number 1. That is Schedule A land, my land.
Okay.
And B to G, my lord, are the other lands. So your lordship sees, for example, Schedule B, about 4 lines from the bottom, Dag number 61, 63, 64. These are the lands, road-facing lands. My land is the land behind their land. So all these lands together combine to make a 6-story building. Now, my lord, what I find is, when the building is constructed, your lordship will see the photographs at 112 is a photograph of the building. Now, my lord, what I am troubled with is at 113. The print is not very clear. My lord, may I just hand over a better copy? So the newspaper advertisement which came out, कुछ नहीं पढ़ाई दे रहा है, phone में है, दिखाओ. Now, these 6, my lord, companies who are the Schedule B companies, B to G, they, my lord, seem to have mortgaged the entire building to this bank, which they could not have. And the bank also, my lord, when it takes the mortgage, it is required to see whether the building is standing only on their land or my land also. So bank also does not do due diligence. Whatever they do, now, my lord, the sale notice has come in respect of your lordship, kindly comes to description of the property, please, my lord. Along with, kindly see, my lord, the property is described now. Kindly see about 4 lines from the bottom. Together with the basement plus ground plus 6-story building having total coverage area of about 1 lakh so many square feet. So, my lord, the entire building, basement plus ground plus 6-story building, is now being put up for auction.
No. What is the quotient number? Your Dag number was not there.
Yes, my Dag number is not there, but the entire building is being put up for auction. That is, my lord, the mischief they've done. They don't mention my Dag number.
Dag numbers were 61,
61, 63, 64.
and 65.
Yes, but the building doesn't come up on 61, 63, 64, 65. Building comes up on Dag number 1 also. That your lordship has seen the agreement. Only then can a 6-story building come up. On these 4 Dags, 6-story building cannot come up. That was the purpose of the agreement, that we will amalgamate the land behind with our land and then raise the 6-story building. What is usually done, my lord? Now, they don't mention Dag 1, that is the mischief they do, but they sell the entire building.
Notice the Dag number 1 was not there.
Dag number 1 was not there. So, if Dag number 1 is not there, for sure, the B plus G plus 6-story building also.
What is the order of the learned court?
Now, my lord, kindly see the order of the learned court. May I just, before I take your lordship, my lord, may I just show your lordship the prayer? Because I admit, my lord, prayer was slightly inappropriately made. Kindly see 159 is the prayer portion before the learned additional district judge.
159.
159 is the prayer portion. This was in regular first appeal. I'm sorry, miscellaneous first appeal before the additional district judge. Kindly come to prayer A is okay, my lord. Set aside the learned civil judge's order. Now kindly see B. An order of injunction restraining the defendant numbers 10 and 11 from proceeding with or acting in terms of or in pursuance of the sale notice dated so and so, which I've just shown your lordship, in respect of the said building, more fully described in Schedule B. This is where, my lord, the learned draftsman made a mistake, my lord. He should have limited his prayers only to 2 stories. Schedule B, now if your lordship sees, and kindly see prayer C also. Alternatively, an order of injunction restraining the respondent number so and so from issuing any certificate, etc., if the auction in respect of Schedule B property. Kindly see once the Schedule B, which is there at page 161. What he has done is cut, copy, pasted from the plain the schedule. Kindly see, my schedule B, all that the B plus G plus 6-story building. This should have, now, apropos this, now kindly see the relief in the plain, because he has just copied the schedule from the plain without noticing, the prayer in the plain. Kindly see, page 40, please,
Page
40 is the prayer in the plain. Kindly see prayer A. This is correct. I don't claim any right in respect of the entire building. The building can be sold apart from these 2 floors. Kindly see, page 40, please, my lord. My lord has page 40, please, my lord. Kindly see prayer A. Decree for declaration that the plaintiffs are the owners of the ground and top floor, more fully described in Schedule B. So this part, the learned draftsman below has missed. He should have limited his prayers only to the ground and the top. Instead, he says entire Schedule B. And this is what, my lord, the learned court below says. Kindly come to, my lord, page 166 is where the order is. The ordering portion, I'm not troubling lordship with 165 where the facts are noticed. Kindly come to 166, please, my lord. This is an order made on 18th, perhaps. Yes, 18th October. My lord has page 166. My lord, may I, on careful perusal of the petition of the plaintiffs, appellants, as well as documents relied on by them, it transpires that Office of the Recovery Officer, DRT 1, Mumbai, issued proclamation of sale under provisions of law. This is correct. In the instant application, plaintiff appellants, now, my lord, this is where, my lord, plaintiff appellants have not sought for protection of their admitted property, but have come before this court by filing instant injunction application for setting aside the impugned order passed by the learned so-and-so, restraining proceeding with the sale notice issued by the competent authority, and also restraining defendant numbers 10 and 11 issuing certificate in the way of execution of sale. So he says you've not sought for protection of these 2 floors, you sought something else, but that is with the greatest of respect. These 2 floors he is correct, but I have sought, my lord, prayer B and prayer C. My admitted property, my lord, is limited only to, now, my lord, he says that you give notice and come, ex parte order, not inclined to pass any ad interim order. The urgency is this, my lord, if your lordship comes back to the sale notice, the auction will be, the money to put in is to be put in within 15 days of 11th of October. Now, sale took place on 12th of October. That is as per the auction notice. The money to be put in by 26th October. Thereafter, any day, the sale certificate will be issued. That was my urgency. And that is why, my lord, I prayed for this ex parte relief. Now I've served the bank, but the bank is not present before your lordship. So, my lord, I'm humbly praying that kindly, my lord, kindly consider prayer C at this stage, because prayer B, my lord, the sale has already taken place. Your lordship, kindly see that. I'm sorry, my coming back to the CO, I was troubling your lordship with the prayer in the petition. Coming back to the CO, please, if your lordship sees my prayers, that the orders be not set aside. Now, my lord, kindly see the second relief sought at page 27, the continuing relief. Ad interim order of injunction restraining the opposite party from proceeding with the sale notice dated so and so. Now, my lord, this has also, because of the passage of time, sale has already taken place. I cannot seek this. All that I can seek is the relief which was sought, which is in terms of prayer C before the learned court below. If my lord may kindly be troubled once with the prayer before the learned additional district judge. Kindly see, my lord, page 160. Kindly consider this prayer, my lord. An order of injunction restraining defendant numbers 10 and 11, who are the opposite parties, my lord, 10 and 11 before your lordship also, from confirming and or issuing any certificate or executing any deed of conveyance in favor of the buyer if auction has already been held in respect of the, kindly clarify here, my lord, not Schedule B property, but only the ground and the 6th floor of this property. I'm asking a lesser relief than what was prayed because I'm not entitled to the full relief. And my lord, if your lordship wants, my lord, it's fairly well settled that if I ask a larger relief, the court is not restrained from granting a smaller relief. Reverse is not.
Certificate has already been issued, I think.
No, my lord, certificate has not been issued because it is to be issued only after 26th of October, on any date after 26th of October.
We have passed the 26th.
Yes, we passed that date, but we are aware, my lord, no certificate has been issued. So I am seeking, my lord, instead of Schedule B property, only, my lord, ground and top floor, my lord, because Schedule B property is the entire building. I have no interest in the entire building. My relief in the plaint is also very clear. Only ground and 6th, which is in terms of my lord agreement at page agreement dated 5th February 2005 at page 98, which restricts, my lord, my right only to the first and the ground and the 6th floor, which your lordship will find at page 100. The second party shall allot in favor of the first party constructed area in the proposed multi-storied building aggregating to 36,000 square feet and would exclusively allot the ground and top floor of the proposed G plus 6-story building. This is my right, my lord. I cannot get anything more than this. So although they have sought in favor of Schedule B property, I will not, my lord, tell your lordship that.
So the opposite party number 10 and 11.
Yes, my lord. 11 is, my lord, the auction house now. His role is also redundant, my lord, now.
Only 10 is there.
Only 10 is relevant, my lord. He
If
is
the sale certificate was not at all issued,
yes,
then you have the right to.
I have. Now, if, my lord, because once sales certificate issued, then third party right created, then I have to implead him, then lead to multiplicity of proceedings, my lord. So if your lordship will kindly provide that the sales certificate has not been issued, it should not be issued in respect of ground and 6th floor. The rest it can be.
Okay, very well. So your agreement dated 5th of February 2008.
Yes, my lord. 2005, my lord.
2000?
2005, my lord. At page 98. 5th of February 2005. And I am the owner, my lord, of Dag number 1, which your lordship will find is my conveyance of 2008. The agreement is the agreement of 2005 pursuant to my agreement for sale, which I had.
Yes. Very well, hard. You have served.
Yes, my lord, I have served by email on 28 February. I'm sorry, 28 October. 28 October, pursuant to the, and the speed post has been received yesterday. That they have received my email, your lordship sees page 3 is my email, attaching, my lord, the CO and the order made by this honorable court. And page 4 is the, they have received it that we value your relationship. Kindly see at page 4 at top, greetings from IDFC First Bank. We are in receipt of your email and will respond to you in 2 working days. So what they've done, I don't know, my lord. This was the email, is their email. And page 8, my lord, would show receipt of the speed post also. Page 8, top, 31st October, they have received the speed post also.
Item delivered.
Item delivered.
Okay, very hard. Please take down. The affidavit of service filed on behalf of the petitioner is taken on record. It appears from the affidavit of service that the petitioner, in pursuance of the order of this court, has served upon the opposite party number 10 and 11 in respect of the petitions along with the connected papers. Stop. Next one. None appears on behalf of the respondent number 10. Stop. Heard the learned advocate for the petitioner at length. Stop. The instant CO has been preferred against the order dated 18th of October 2023, passed by the learned additional district and session judge, first of Fourth Court Barasat, in Miss Appeal number 133 of 2023. Stop. Next para. The learned additional district and session judge has refused to pass any interim order of injunction in favor of the petitioner. Hence, the instant CO has been preferred. Stop. The brief fact of the case is that the present petitioner is the owner of dag number 1.
Dag number 1, my lord.
Within the
Premises number 1, Koikhali Road. The schedule is at page 76, my lord. Premises number 1, VIP Road or Qazi Nazrul Islam Avenue. Page 76, your lordship sees, is a schedule of my conveyance.
76.
Yes, please, my lord.
Yes. The petitioner is the recorded owner, of a plot comprising an area of 15 katas, 13 chatak and 34 square feet, more or less situated lying at and comprising a portion of dag number 1.
Yes, my lord.
Recorded in Khotian number 581 in Mauja, Koikhali, jail 5, Toji number 172 under police station airport, formerly Rajarhat, within Rajarhat, Gopalpur municipality. Specifically situated at 1 Qazi Nazrul Islam Avenue, Calcutta 52, under district of North 24 Parganas. Stop. And stop. Next para. An agreement was entered between the present petitioner along with the opposite party number.
My lord, opposite party numbers 1 to 9. 1 to 7, my lord.
1 to 7. Who are 8, 9?
8, 9 are the promoters, my lord.
Okay, very good. 1 to 7. On 5th of February 2005, 1 to 7, 2 to 7. For using such land for the preparation of a building comprising of 7th floor.
6 floors. Ground, basement, ground plus 6.
6th floor. Stop. It has been It has been specifically agreed between the parties that the present petitioner would have only right over the ground floor
and top floor.
Over the ground floor and top floor of the building. Stop. On the basis of such agreement, the building was constructed. Next part. It has come to the knowledge of the present petitioner that the office of the Debt Recovery Tribunal 1 Mumbai has initiated a proceeding in respect of the other owners of the property of tag number 61, 63, 64 and 65. Stop. It is the fact that the DAG numbers in question before the learned Debt Recovery Tribunal is also comprising the said building along with the DAG number 1 owned by the present petitioner. Stop. Finding no other alternative, the present petitioner has preferred a suit before the jurisdictional court and prayed for an order of injunction. The order of injunction was refused, against which the misappeal has been preferred before the learned first appellate court. Stop. Next, the learned peruse the order passed by the learned first appellate court. It appears that the learned first appellate court, after carefully perusing the prayer of the injunction application, is come to the opinion that the plaintiff, that is petitioner herein, has prayed for injunction in respect of entire building over which he don't have the exclusive right. Stop. Next, learned advocate for the petitioner referred the prayer made in the plaint itself, wherein the declaration was only sought for in respect of ground floor and top floor of the building. Stop. It is admitted by the learned advocate for the petitioner that the sale procedure has already been initiated by the respondent, that is opposite party number 10, in respect of the
Opposite party stay.
disputed plot number 61, 63, 64 and 65. Stop. He submits that if the sale certificate was issued in respect of ground floor and the top floor of the building, the multiplicity of the proceeding would be cropped up. Cropped up. Stop. So he prayed for an ad interim relief. Had the learned advocate peruse the impute order passed by the learned additional district and session judge, it appears that the learned additional district judge was quite justified in respect of the fact that the plaintiff has made an erroneous prayer at the injunction application, but at the same time, it has to be looked into that the main prayer of the plaintiff cannot be ignored. The petitioner has specifically argued that he don't have any right over the other portion of the building except the ground and
And
top floor of it. Considering the same, it appears to me that the sale proceedings, procedure has already been initiated by the respondent number 10.
10 and 11, my lord, both. Sale procedure done by both 10 and 11.
Opposite party number 10 and 11. Opposite party number 10 and 11. And I have been informed by the learned advocate to the petitioner that the certificate of sale in respect of the ground and first top floor of the building was not issued at all.
Certificate in respect of the entire building has not been issued.
Okay. No, you have only right over that.
Yes, yes.
Just specifically.
Yeah, please, my lord, please.
Stop. Ground not issued till today. Stop. Considering the same, it appears to me that the plaintiff stroke the petitioner is the rightful recorded owner over the dag number 1. Stop. He has entered into the agreement with the parties in respect of ground and top floor of the building. Stop. He has the right over the said portion of the land, said portion of the allotted building. So any sale procedure initiated in respect of the said portion of the building would appears to be not legally tenable. Stop. I make it clear that the dag number 1 is not made in the schedule of the land mentioned in the notice dated 8th of September 2023.
Yes, ma'am.
The said as the said notice also is also not binding upon the owner of dag number 1. Considering the same, the opposite party number 10 is hereby restrained to issue any sale certificate in respect of ground and top floor of the building in question if already not issued by them. Next, the interim order passed by this court shall be extended till the disposal of the suit, and the principle of lispendence shall always apply.
Grateful.
Principle of lispendence shall always apply.
Yes. My lord, your lordship has said building, if your lordship will kindly specify, situated at 1 VIP road. My lord, that 1 Qazi Nasrul Islam Avenue, if your lordship kindly only gives the address of the building. Because the dag your lordship has said.
Dag,
Dag,
where I mentioned the dag?
last, at the end, yes.
Okay.
And building your lordship has, ekdam sheshe dige, madam. Sheshe dige, your lordship said ground and top floor of the building situated and being 1 Qazi Nasrul Islam Avenue.
Situated, situated at 1
Qazi Nazrul Islam Avenue.
Avenue. Yes. As mentioned at above.
Yes, yes, my lord.
As specifically mentioned above.
My lord, I made one mistake. I told your lordship 127. It should be 227. Agreement যেখানে 1227 টা ওটা 12. Opposite party numbers 227.
Entered into agreement with 227.
Let the CO then may be disposed of since see they have
the CO is disposed of connected CAN application.
They're connected along with CAN to nahi hai na kuch? There's no connected CAN.
CO is disposed of.
Grateful, my lord, deeply obliged. Deeply obliged. Yes.
Item 5.
Plan for the petition, my lord. Petitioner before lordship is a tenant, and my lord, against the ex parte order, he filed an application under section 47, my lord. And that hearing was going on, and in the petition you have taken, my lord, that suit paper property is wrong number given, wrong, and in legal layers are not the legal layers. Plaintiff is not the legal layers. That is my submission. Then, my lord, I filed an civil divisional application against the order dated 9th, 3rd, sorry, against the order dated 3rd May 2023 before the learned district judge. That is at page 12, my lord. My lord, that is rejected, my lord, and I preferred a revisional application before this Honorable High Court. That is at page 13, my lord. That is the main matter, my lord. And the revisional application disposed of by Honorable Justice Hiranmay Bhattacharya, my lord, that holding that you file a separate application challenging the order of the 3rd May 2023 and given liberty to file this, my lord. That is at page 13, my lord. Third para. Case is at the stage of evidence, my lord. Thus we have seen it, my lord, at page para 13.
Yes, what is the
Then
order dated
thereafter, my
3rd
lord, the
of-
order at page, my lord,
3rd of May 2023.
my lord.
Order is 3rd of May 2023.
Yes, my lord. And thereafter also, my lord, when I filed the revisional application before this Honorable High Court, I prayed time before the learned court. They told no, not time will be given. They stopped closed the evidence and fixed the for argument and judgment. That is also what I have shown before the Honorable Justice Hiranmay Bhattacharya. Tell me that you challenge all these things. Next certificate copy and challenge all. That is also I have challenged, my lord. My losses kindly see order dated 3rd year. That is, it is clear. It is at the evidence stage.
No, why you filed CO 3137 2023?
That is filed, my lord, challenging the order of the learned district judge.
District judge dated 3rd of
No, no,
May.
no. District judge order is, my lord. Learned district judge order at page 12, 25th July 2009. Page 12.
Page
12.
page 12.
P2.
Civil revision application is rejected,
Rejected.
being not maintainable.
Not maintained. I preferred a revisional application against that, my lord. Yeah. Then, my lord, this
And
order.
this court given you liberty to prefer revisional application, prefer a
Changing
CO against the order dated 3rd of May.
That is, my
What
lord,
is
that
the
is
order
that.
of 3rd of May?
Yes, my lord, that is one certificate copy. Certificate copy. First
So you are the defendant tenant.
tenant,
Defendant tenant.
my lord. My lord, losses can you see 3rd May 2020.
Yes, read out.
My lord, losses can you 2 days fixed for hearing for petition to be filed by the petitioner, learned cause, examination of the OPW to continue. Both parties file Hajira. Plaintiff does not file any petition. Instead, learned advocate on behalf of the petitioner highlighted the provision of Section 8 of the Hindu Succession Act 1956. OP objected to the same. Had both sides perused the material on record considered. It appears that the court had asked the learned advocate on behalf of the petitioner to show the legal validity regarding the nature of question that can be put. Witness, vice the chastity of the mother of the witness, and whether such question can be put in witness to the witness. Further, the court had asked the petitioner to show whether the question regarding the legitimacy or as a child can be put to the witness. However, learned advocate on behalf of the petitioner could not show any law by the virtue of that, as question could not be put to the witness he only managed to show the provision with regard to the succession vice legitimate children. It is pertinent to note that decision on this question is pending following the reference view of the Supreme Court in Kaiser, that is one reference given. It has held that the case that a child born out of the legally valid marriage is entitled to all rights of and privilege available to the children born out of the wedlock. Under the circumstances and owing to the petition failing to provide any legal basis to which the questions the petitioner is directed to produce with this cross-examination on the next date, and it barred from asking question on the points.
Yes, I have read out. I have read out.
Mala losses then I have challenged then when it was.
No, who are you?
I'm the defendant. Yeah,
You are the
tenant.
defendant.
Tenant.
Defendant tenant.
Tenant one. And losses next comes the next order, next page order. The 2 days fixed, that is 26th May, yeah, when the divisional application is pending before this Honorable High Court, today is fixed for further OPW, if any, that is OP files Hajira, heard the OP in full, petitioner files a petition praying for adjournment on the same ground on previous date. That is my previous date also under the pending civil divisional application. Said pair is rejected, fixed 20th November 2023 for argument by the petitioner and delivery of judgment. Now losses can you see? Next page, my lord. Next page. My next page, para 1, my lord. I have clearly stated, my lord, that the CO, last para, that the petitioner I have named has preferred and civil divisional application under Article 227 of the Constitution of India against the impugned order dated 3rd May 2020 in connection with the case, order dated 25th July 2023 in connection with the civil divisional application 8 of 2023 passed by the learned district judge.
Why are you aggrieved, sir?
My lord,
why are you aggrieved?
My evidence has been closed. I cannot put other questions.
You don't have filed any petition for filing evidence or like that.
No, yes. The case is on that evidence stage, which will be clear from the order, my lord, of 3rd May. Evidence. I cannot put that question.
I understand.
I understand, my lord. She can see last year. The petitioner, my lord, last 4 line, my lord. Under the circumstances, owing to the petitioner failing to provide the legal basis of put the question, the petition is directed to proceed with the cross-examination on the next date, and is barred to asking the question on the points of chastity of the witness, mother, and their legality child. I have challenged this before the honorable, now before your lawsuit is undertaken. So it is at evidence stage, my lord, it is clear. So, my lord, the order thereafter, my lord, subsequent, when I filed the application, well, I said that the case, my lord, losses can be seen, last page, last by 1 page, my lord, para 1. I have said that the case is pending before this Honorable High Court. So, my lord, after praising all this, my lord, his lordship, the Honorable Justice Hiranmay Bhattacharya was pleased to give me liberty to challenge it. He told me if you have certificate, I can grant order now and then. So if you please take the certificate copy and file it. Because I have filed the certificate copy before the district judgment, learned district judge. So this is I have to, my lord.
No, the issue is not that. Why are you aggrieved?
Well, because evidence has been closed.
No.
I have to keep.
No, the impugned order dated 3rd May 2023 was passed against the petitioner.
All the questions have not allowed me to go here. That is my losses can come. I cannot put the legality, validity, and legal airness of the My losses, the question is short section. Question of the next date and barred from asking the questions on the points of chastity of the witness mother and their legal legitimacy as a child. That is my the question. And that is my so I have challenged.
You
I'm
are
the defendant.
you
I'm
are the defendant.
defendant.
But the question, the petition was filed by the plaintiff.
No, plaintiff, not plaintiff. This is my pay. My pay.
Today is fixed for hearing the petition filed by the petitioner.
Petitioner, I am
petitioner
petitioner in the miss case. I am petitioner in miss case.
Okay, you are the petitioner in the miss case.
And I paid time since the case is pending before this Honorable High Court. And that the losses can come last year. Last year, seen it, the para 1 that the petitioner above named in prepared and civil divisional application under Article 227. And I have given the number. Given this order passed, evidence closed, and only for judgment and argument.
I understand, but where is the impropriety in the order 3rd of May? Where is the impropriety of the order?
That is he has closed the evidence. Let us see.
Not close the evidence.
Close
No,
not
no,
enter evidence. I cannot put the
Not close
questions
the evidence.
with
No, no,
legal yes.
you just see the order dated 3rd of May.
I have seen.
He has not closed the evidence on that date.
Not I cannot put question to that extent.
Yes, you cannot put question regarding the chastity
Yes.
and the
Because my
child or illegitimate child like that.
I said that the suit plot is wrong. That is not
that is a separate issue.
that is my legal layers. They are not the legal layers. The plaintiff is not the legal layers. Losses kindly come to page 10. So that is
not the issue here.
And
that is not the issue in this CO.
You
have given liberty to file this civil CO only in respect of order dated 3rd of May 2023.
And thereafter, this order also, I have shown. You challenge it. That is also I have challenged.
You just read out the order.
That I have seen. That I have seen.
In view of thereof, CO such and such
time. That is seen. But
as withdrawn with the liberty.
Because that is not if not that is limitation may come. But I am challenging also this order.
No, limitation is not come as you have given the liberty.
And liberty. So liberty when
the explanation regarding the validity of the order.
Losses can see the order dated 26th September 2009. So let me allowed to put the question. Witness must be going on evidence. Evidence.
You can only challenge the order dated May 3rd, 2023.
No, subsequent order I have also challenged. Subsequent order I have.
Subsequent order, how can
you
challenge?
I have put there.
You have not given any liberty to file the.
That is since that time I have in that order in my hand. I shown the order. This is the I told. Namely challenge everything. So that is no Barmalo, the subsequent order I have also given. Losses kindly see the pair portion also. I have stated the order dated 26 September 2023. That is my evidence has been closed. But when the case is pending before your lordships, if I create time before the Runnet court, that case is pending, and one lordship know the pending of the cases.
How many evidence are there on your view? How many evidences are there?
Plenty will give evidence, and I will give evidence. Plenty will give evidence. The land. Yeah.
No, initially.
And then I'll give evidence.
You have to adduce evidence. How many witnesses are there?
Well, that I have to hear my pain. I hope
no. You just confirm me the date. I can award you only one date by disposing of the CO.
So, losses take it to perhaps may I talk with over phone and come back within 5 minutes? Or let's fix any date for complete 1 or 2 days to complete the evidence. Any day.
No.
Subsequent date
cannot be
continuous date
going on like together. This is proceeding under section 47. You have challenging on execution proceeding.
5 minutes time, I will cannot. Landed advocate for the.
No, whether you have served.
No.
Initially today moving this matter.
No caveat.
Okay.
No caveat.
So you serve and come on 8th.
One lot. Fundamental losses can issue. Date fixed on 14.
14th of
28th November. That is, our court is opening on
28th of November.
court is opening on 16th, then 17th, then 18, 19 is Sunday. 20th November, the only. I will get still 1 day, and in the meantime, any not to attend, then I will. Rashid, give me limited time, I will serve and let it appear any day. Limited stay, or Rashid direct to dispose of the evidence within 1 or 2 days.
No. I have to hear the other parties also. Okay. Please take down. The petitioner was given liberty to file this instant CO by virtue of the order of this court passed on 9th of October 2023 in CO number 3137 of 2023. Stop.
Since when at the relevant time that matter was challenged before this honorable court. That is when I have that copy also. That revisional application.
Revisional application number 3137.
Yes, sir.
37 of 2000. Stop. Heard the learned advocate for the petition. It appears that the evidence of petitioner in Miss case number 10 of 2016 within bracket under section 47 of CPC bracket close has been closed. Your evidence has been closed.
Closed and
stopped. However, it is the argument on behalf of the petitioner that he want to adduce some more witness before the learned court below. Considering the same submission, it appears to me that the instant CO has got merit to hear the matter. To merit to entertain, stop, merit to entertain. Accordingly, the petitioner is directed to serve upon the opposite parties informing the fact that the matter shall appear in the list after 8 on date on 9th. Okay, 9th of this month.
then I have
Stop. The petitioner is further directed to file an affidavit of service on the adjourned date.
in the meantime,
No.
if the age doctor can fix it at 8. Because, my lord, if I miss the 8, then line, every
The court is closed. It will be open on 16th.
what happened?
I find no urgency to pass any order. As because I fixed the order on 9th, the court is opening on 16th, lower court. So what is the order?
Fixed on 26th, 28th November.
Yes. Prior to that, I fixed the order. So what is your urgency?
9 plus the
Yes, 9th. Then takes. Next.
Item 10.
In this matter, Lordship, I beg to appear in person.
Item 10.
10, Lordship. Lordship, I am the petitioner father and I filed an application under Guardians and Wards Act before the Learned District Court at Barasat for returning custody of my minor daughter. In that matter, several orders have been passed. The matter has come up before this honorable court also. Subsequently, in June 2022, an order of visitation was passed by this honorable court. Now the opposite parties are not adhering to that order, and I have filed an application for contempt also, which is pending before this honorable court as of now. Now, Lordship, in the meantime, I have filed several applications for special visitations right on occasions. That has been granted from time to time. Even on the last year in Puja vacation, I filed an application and order has been granted. Now, in this Puja vacation, on 19th of October, I filed an application praying for interim custody of my minor daughter during the festivities. On that occasion, by the impugned order, the learned trial court was pleased to reject my application only on the ground that since an order has been passed by the honorable court for visitation, they cannot pass any further order. Lordship would kindly take the matter. They kindly take the impugned order itself. It's the server copy, last page, Lordship. Order number 109 dated 19/10/2023 on the last date of the civil court. On perusal, may I submit the order, Lordship? On perusal, petitioner files a petition praying for interim temporary custody of the minor child on and from 17/10/23 to 16/11/23, along with another petition praying for put up of the record. Learned advocate for the petitioner is present, none appears for the opposite party. Prayer for put up the case record is considered and allowed. Heard the learned advocate for the petitioner who moved the petition filed today praying for interim custody. On perusal of the record, it appears that the Honorable Court in CO number such and such with CO number such and such has been pleased to pass an order on 7/6/2022. That was last year, Lordship. That is still subsisting, by which direction was given to the mother opposite party to produce the child at Eco Park, Newtown, Kolkata at gate number 1 on every second and fourth Saturday at 4:30 p.m. to 5:30 p.m. in order to ensure visitation right of the petitioner father for his daughter. In view of such order passed by the Honorable Court, this court cannot pass any other orders by which the petitioner father can be allowed to get interim custody of the minor daughter from the period from 17/10/23 to 16/11/23. Now, Lordship would kindly come to my petition. Lordship would kindly come on page number 19.
No, okay, I understand. I understand.
And
So,
Lordship, may I submit one
Learned
certified
additional
copy
district judge
of the order
not
passed in
interfere.
last year? This is the
No,
order.
no, just not necessary.
In this, they have given the learned trial court has given me liberty and given me for visitation right on last year Puja vacation. But this year, it has been rejected on the ground that that order is subsisting.
I understand. So the issue is that
Very small issue, Lordship. Only I want to visit, take interim custody for a few days during the festivities. That's it. The remaining matter is being heard and the order may be passed accordingly in the trial court. I am not on that. I am only on the point of having temporary custody of my daughter during this festivities. Only that point, Lordship.
so you serve common 8.
Lordship. Lordship, if I may,
You are the father.
I am the father.
Yes, what are you submitting?
Lordship, I may pray for an indulgence. On 8th, let the matter be placed before a different single bench, because on 8th, the civil matter is taken up by Justice Vishwajit Basu. And Justice Vishwajit Basu is my immediate senior. So he won't take my personal matter. So on that day, he will release
And
the
on
matter.
9th, come on 9th.
As your Lordship.
On 9th. If the Mr. Basu is not there, Justice Basu is
Lordship. Because
not there. Very
since he will release the matter again, it will go
again,
to a
again.
different
Okay,
bench.
I'll fix you on 9th. Petitioner appears in person. Stop. Petitioner is the father of a girl child, namely
Navya Shah. NAVYA
Navya Saha.
NAVYA SHA
NAVYA. Navya Saha.
SHA.
Navya Saha. Is it about
Presently 8 years.
8 years?
8 years. Presently 8 years.
8 years. Stop. The daughter of the petitioner is now in custody with her mother. Stop. On several occasions, the petitioner was given visitational right of the minor by the order of this court passed in CO number 916 of 2022 with CO number 1677 of 2021. Stop. The present petitioner has preferred an application before the learned district judge for interim custody for the period from 17/10/2023 to 16/11/2023. The prayer of the present petitioner was turned down on the ground that this honorable court has already passed an order regarding the interim custody. Stop. Being agreed by the said order passed by the learned additional district judge, the instant CO has been prepared. Stop. Having heard the learned advocate, but the having advocate the petitioner in person, I find merit to entertain the instant CO. Accordingly, the petitioner is directed to serve to the opposite parties, informing the fact that the matter shall appear in the list in the vacation bench on 9th of October to 9th of November 2023.
What?
All concluded?